church, church, church. Been in the game a decade, not one successful remake, becoming the old head rugged rapper with supreme aim. Made roads nobody knows about famous, you know the street names. No PR to play my album when it drops, I got respect, it's my campaign. Bar for bar, you throw some shots, no police still gon' get detained. We ain't standing on the level near each other, that shit fake. I just treat them like they kids cause they imagination crank. Merit badges on they jacket, trying to claim they high and right. My goons gon' get a wrench and bust your head, we still running the block today. We out here acting too ratchet and tight. MHBs hop out GMCs and hit you with the tools like Harbor Freight. I put you in a stolen truck and roll that bitch into the lake. True crime, that shit, bitches. My lawyer said I had to tell you I'm just kidding, cause court got me doing way too much spinning. Just know I'm done with all y'all shit for real. You better fill me catalog after this long, worth about 100 million. Sick of being sick of tired, now I might fuck go down and kill you. Remember, I'm just writing entertainment scripture for some other people. What? Scared of me, ought to be audio. Honestly, when I state opinions, everyone calling me. Don't give a fuck if a blue chicken follows me. Bitch, I'm ballin' and you can come swallow me. They call me Nazi, I say that you're not a B. Need a beat, wanna feed, go get it, not from me. Solid commodity, hip-hop anomaly. Up to the church and the Holy Ghost following. Super duty, not my fault. Hip-hop is now a shit game. Chipping different since Wayne made a soundbite out of lit flames. Ain't no real artist out fishing for the quick claim. Fuck a red carpet, tell them roll me out a brick lane. Coming through like Mad Max, got 9 lives on a bad cat. Murders paint the game matte black, I'm a road boy, you don't need math. This that trailblaze music, redneck hell, race music, blue collar popping, truck thumping in a champagne Buick. No Slim Shady, too much barbecue, plus everybody know I got the juice like Tom Brady. I'm touching down, patriotic partner chilling in the booth. Paid homage to who needed, now I'm collecting debt from dudes. Gimme. Don't call me asking who, I only talk to people living around my crew. Hey, mother. Okay, I ain't worried about the police when I'm cruising. Hellcat ain't no thing, my dusted boots gon' lose. Driving still be something, action movie stupid. So many lanes, but Luke couldn't even do it. Hey, fuck it, I ain't worried about the police when I'm cruising. Hellcat ain't no thing, my dusted boots gon' lose. Driving still be something, action movie stupid. So many lanes, but Luke couldn't even do it. Kalani on the beat, mother.
Where the hell's Kane? Because this is his idea. He didn't want to go live. So he better bring his ass on. I don't know what we're talking about. Hang on, y'all. I was seeing if there was any more. No, I'm not making from the dang channel. I was trying to see if there was docs or whatever. Where the hell's Kane? I swear. There is something going on in Delphi. Hang on, let me find it. I'm gonna beat Kane's ass because he wanted me to go live, so I did. Where's he at? Yes. All right, hang on. Did I vacate your channel? No, I hadn't. I haven't been going to anybody's channel really a whole lot because everybody's fighting. Y'all making me nervous doing all that shit. Hang on. I hadn't even been doing lives. Like the last live I did was a hurricane thing. My stickers just turned off because they're retarded. Okay, hang on. What the hell is this? Ew. What's that? Where's. No, I just saw something. I think it was this. I don't know who this lady is. She's a lawyer, but. Love you too, Robert. Where in the hell is Kane? We're gonna watch this. No, because I was gonna watch it anyway.
Two extremely important cases have broken in the final weeks leading up to the trial of Richard Allen. First, there are absolutely shocking allegations against one of the prosecutors prosecuting the case against Richard Allen. The allegations are that he helped file 2 affidavits without probable cause in a different case, and saying that their allegations isn't really quite correct. A federal court stated this: defendants Luttrell, that's the prosecutor, Krug, and Wisenand are liable under Section 1983 for violating plaintiffs' Fourth Amendment rights by drafting, reviewing, and ultimately submitting an affidavit to a court which they knew they did not have evidence to support. And here's another quote: each of these statements without any evidence to back them up are fabricated statements. So the court found that the defendants, including Prosecutor Luttrell, are liable for several claims. We're going to go into the details tonight. And on the other side of the coin, one of the key witnesses for the defense was arrested. Is this just something to discredit a witness for Richard Allen? Is this Karen Read all over again? Is there a conspiracy?
Who's that?
Wasn't sure what insurance I needed for my shop, so
By law enforcement and by the prosecution against Richard Allen, or are these cases completely separate and irrelevant to his case? I'm going to tell you about both cases and then give you my analysis at the end. And tonight is for all the people who have said, oh, Lee must be really for Richard Allen. Lee must be defense oriented, because I am going to give you the unvarnished truth as I see it. I'm going to analyze it straight up. So listen to the end and you'll find out. So tonight we're going to cover 4 things. Briefly, what happened in Karen Read. It's like about a minute so you can compare the two. Then I'm going to talk about the allegations against the prosecutor in Richard Allen's case, not in the case, but against the prosecutor who is prosecuting the case. There are 3 different prosecutors. This is one of the 3. The allegations then against a key defense witness, Todd Plick, and then I'm going to give you my analysis. I want to say a special shout out to the first 5 in the live chat tonight: Tina Duer, Taylor Tyree, Bonnie Edema. Grisly, barbaric killing that occurred back in 2017. And we are going to, I'm included, I'm all the way up here. I'm hundreds of miles from my home. I'm going to be here for a month because I think this case is that important. It's not televised, and there are a lot of questions and allegations that have been made about whether Richard Allen is receiving a fair trial. I want to know that he is. I think it's super important that people in our country be given a fair trial and that it be public. And that's why I'm here, to be your eyes and ears in the courtroom when we can't have a camera. And it's really, frankly, very difficult to get information about what's happening in the case. So let's dive into tonight. Lee Miller commenting on the courtroom. Oh my gosh. I think that the Allen County Courthouse is phenomenal. It's just gorgeous. I haven't seen the Carroll County Courthouse. I have been told it's very hard wooden seats. So we had a day off today and I bought a cushion for the very hard wooden seat I've heard about. All right. So quick overview of Karen Read. In the Karen Read case, her legal team insisted that she was being set up by a conspiracy of police officers and family members. She was accused of hitting her boyfriend with her car after she dropped him off at a party at some fellow police officers, at the home of fellow police officers. He was found, the boyfriend, in the snow the next morning. He died shortly thereafter. Karen Read says that the people inside the house, the police officers who knew him, some of whom knew him from work, injured him, dragged him outside and left him to die in the snow. She, on the other hand, was prosecuted for killing him by hitting him with her car. She said that Trooper Proctor, the lead investigator, was in on the conspiracy against her. A federal investigation uncovered some really appalling and very offensive text messages he wrote about Karen Read. In fact, I tried simply having the actual statement from the court in my YouTube video, and YouTube demonetized it until I eliminated that. That's how offensive his language was. So is the same thing happening in the Delphi case? Are these cases evidence that Richard Allen is being set up? We're going to take a look at the 2 cases and whether they suggest any attempts to influence the trial. So let me say a thank you to Amanda Thee, who gifted a Lawyerly membership. That's awesome. We love our members here. And thank you, Amanda Thee, for gifting the Lawyerly membership. And trial will take place. So let's take a look at the allegations against Luttrell and ask the question, is it possible that these allegations will somehow come in or help Richard Allen at his trial? And it's important to know, as you kind of think about that and as we talk about it, what I'm about to show you is a civil case filed by an individual. This is not a federal investigation, as in the Karen Read case. That's where, and by the way, they weren't allowed to say there was a federal investigation in the Karen Read case. They were just allowed to use the evidence that was gathered in the course of that case. Now, nobody can be, out of the case I'm about to show you, nobody can be criminally charged. This is a civil case. The most that can happen is one side is forced to pay the other side money. This is not something where somebody is going to go to jail. This is a different kind of case. So, and I want to thank Trenton for sending this to me. Thank you very much. So the overview of what this case is about is a doctor says that he was unfairly prosecuted. And the reason he claims that he was unfairly prosecuted is that there was a private company that was being used to take civil funds. It's so complicated. Let me see. Let me break that down further. In the course of a case, the government can freeze assets and take funds that people have that came from the crime that was committed. So let's say you went out and robbed a bank and then you deposited the money in your bank account. The government could freeze the funds that are in your bank account and say, the reason you have those funds in your bank account is you stole them from somebody else. We're going to freeze those and we're going to prosecute you on the bank theft that you did. So what they said was that this doctor had been overprescribing opioids, and therefore they wanted to freeze his funds that he had received from the opioids, and they froze all of his accounts, and you'll see the allegations against it. In a nutshell, he says that their reason for doing that was really thin. And you'll hear how he says that the reason it was done was because they had hired a private company to do this forfeiture proceeding, and they were going to get a percentage of the money. So that's his argument. So let me get that. Let me share my screen with you so you can see this complaint. And I want to start with the complaint. It's old, 2020, but there was an order that came out just about 2 weeks ago. And that's what that we're going to talk about tonight. But I first want you to understand what the allegations are. So the case is Economan and Associates Family Medicine. And I may not have said that right. And against a number of people, including, and you'll see James Luttrell there, right, the prosecutor who was also involved in the Allen case. Oh, I don't have that on the stage yet. Oh, it says, okay, it's saying it can't access that. Seems like that happened to me one time before, but I don't remember why. Oh, there we go. Yay. Okay. All right. So here we go. And I was just showing you up here the style of it, filed in the Northern District of Indiana. This is a complaint filed in federal court against all of these people. Plaintiffs are a physician and his solely owned medical practice who were falsely accused of operating a pill mill by way of a forfeiture action and criminal complaint, resulting in the seizure and loss of all assets and complete destruction of reputation. So he's saying he was accused of these things falsely. They froze all his assets because they said they were the profits from a crime, and all of this was unfair. And then we're going to unpack what his allegations are. These are the people who are sued. Tonda Cockrell, a sworn law enforcement officer employed by the United States Drug Enforcement Administration and the Kokomo Police Department. She's sued in her individual capacity, and Gary Wiseman, a civilian investigator employed by the United States Drug Enforcement Administration. He's also sued in his individual capacity. The Garrison Law Firm is a law firm located in Indianapolis, Indiana, and hired by the Grant County Prosecutor's Office to handle all forfeiture cases filed in Grant County, Indiana. And then James Luttrell served as the Grant County prosecutor during all relevant times, representing the 48th Judicial Circuit in Indiana. So they go on to say that as the concern over the prescription of opioids grew nationwide, Dr. Economan sought the advice of and employed an attorney, an office manager, a local healthcare specialist, and a medical billing company in order to establish clear office-wide procedures regarding the prescription of opioids. In other words, he's saying he went to great pains to make sure he did not overprescribe, to make sure that he was complying with the law. Now, I'm not making a statement whether he did or didn't. I'm simply saying this is what the allegations in his complaint made 4 years ago were. And then we'll get into the new document that was filed by the court, an order from the court about 2 weeks ago. This is what the doctor alleges the conspiracy was. And he alleges that the prosecutor, Luttrell, was involved in this conspiracy. In July 2015, local law enforcement, the Medicaid Fraud and Control Unit of the Indiana Office of the Attorney General, DEA agents, Grant County prosecutors, and Joint Task Force officers met to discuss and conspire upon information and belief, a multi-pronged attack to take down Dr. Economan and EAFM, his company. Upon information and belief, this meeting occurred on July 16th, 2015, and was tape recorded. Upon information and belief, the plaintiffs were targeted in large part because the defendants were aware of their financial assets and the potential to seize those assets through forfeiture proceedings. So they're saying the whole reason for doing this was to get the money, to get to the money that he had. That's his allegation. The first prong of the attack would be to seize the financial assets and accounts of Economan and EAFM through the forfeiture process. The second prong of the attack would be to seek summary suspension of Dr. Economan's medical license. On July 29, 2015, local law enforcement, the Medicaid Fraud and Control Unit of the Indiana Office of the Attorney General, DEA agents, Grant County prosecutors, and Joint Task Force officers executed a search warrant on the residence of Dr. Economan and EAFM. The criminal allegations contained within the affidavit used to secure the search warrant accused Dr. Economan of illegally prescribing opioids or prescribing them without a legitimate medical purpose to approximately 50 of his 2,500 distinct patients. However, the search warrant affidavit was devoid of any real probable cause and that it lacked any medical opinions or sworn statements from any medically trained individual attesting to the medical illegitimacy of Dr. Economan's prescriptions or practices. So breaking that down, what he's saying is that they decided to go after his assets and then to get his medical license suspended. That would make him essentially defenseless because he wouldn't have enough money to mount any kind of realistic attack. His accounts would be frozen and he would no longer be able to practice medicine. So he's saying this places him in a place where he can't truly defend himself. And that it was done with a search warrant and criminal criminal allegations contained within the affidavit that weren't true, that were saying things that were incorrect, or at least were not sufficient. Nevertheless, and on the same day, July 29, 2015, a forfeiture action was filed against Dr. Economan and his company in Grant County, Indiana, under cause number, again alleging that Dr. Economan was operating a pill mill. The forfeiture complaint was filed by the Garrison Law Firm on behalf of James Luttrell, then acting as prosecuting attorney for the 48th Judicial Circuit, in other words, Grant County prosecutor, they call him. And in return for its prosecution of forfeiture actions, the Garrison Law Firm receives a percentage of those funds successfully seized through forfeiture actions filed on behalf of the county. So he's saying, why are they doing this? It's because they're going to get a percentage. Not Luttrell, that doesn't seem to be the allegation, but the law firm that was hired to go after the assets would get a percentage. And then they alleged that there were two separate and distinct probable cause affidavits submitted under the express penalties of perjury. One was by Gary Wisenand and the other was by Tonda Cockrell. And I mentioned them earlier. They were both sued individually in the case. The Garrison Law Firm requested seizure of any and all property, and it was on behalf of the Grant County prosecutor, belonging to Dr. Economan or EAFM. And they said alleged with specificity certain accounts that they believed and had good cause to believe are proceeds from said criminal enterprise. And he's going to say, no, you didn't. You had no reason to believe that these were directly from a criminal enterprise. And he'll go on to say that they took, which effectively served to seize Dr. Economan's entire life savings and all accounts belonging to EAFM, his company. All allegations of criminal conduct were limited to the period of time that EAFM existed, or from December of 2012 to July of 2015. Nevertheless, included specifically in the seizure order were two separate IRA accounts that were established in the 1980s and had received no deposits, contributions, or withdrawals in the previous 5 years. So he's saying, you weren't carefully looking at whether or not there were funds that actually had moved from this alleged criminal enterprise, which he says wasn't even a criminal enterprise, but you weren't even looking at whether or not the criminal allegations related to these accounts. You just took everything. So he's arguing you can't do that. There were some that were so old, they clearly had nothing to do with this particular allegation. In August 2015, the defendants began the second prong of the attack. On August 26, 2015, Jessica Krug sought an emergency suspension of Dr. Economans' medical license. And now skip a little bit here. They appeared before the board. And in fact, what happened, Wizenen said, and during questioning before the board, that Economan was the third highest prescriber of controlled substances in Indiana, and that the deaths of certain patients could be directly attributed to Dr. Economan's prescriptions. Neither, and the allegation here is neither of these statements were in fact true at the time they were uttered under penalty of perjury. So these statements were made under oath, but he's saying they weren't true. It wasn't accurate. And he did, in fact, lose his license and said he never practiced medicine again. This was the end of his medical career. Cockrell affidavit, he next talks about that and says the probable cause forfeiture affidavit submitted by Cockrell consisted of 2 pages, and she alleged under the penalties of perjury that through her investigation, she identified certain accounts containing significant funds that are proceeds from the criminal enterprise described in the affidavit of Agent Wizenen, DEA. So there was first the affidavit from the Agent Wizenen, and then she said, yeah, these accounts I've listed here, these are the ones connected to the crime. And this complaint says, no, they weren't. And you had no real reason to believe many of these were connected in any way to what you were alleging. On October 2nd, 2018, Cockrell conceded in her sworn deposition that the information contained within her July 2015 affidavit was false. Now, I will say this, reading statements like that in a complaint, I often kind of discount that. You know, lawyers make very broad statements, maybe oversell it a little bit, but you'll see a lot of this repeated in the order from the court. So that means the court has made a finding on some of these things. I don't remember if that exact statement was, but I'll show you in just a minute the order from the court and what that says about it. Specifically, Cockrell admitted that she had no information to support her statement that Dr. Economan's accounts contain significant funds that are proceeds from the alleged criminal enterprise. Described in the affidavit of Agent Wizenen at the time she swore and affirmed the same to be true. In fact, the only information Cockrell knew concerning the existing financial assets and accounts of either Dr. Economan or EAFM when she submitted her signed affidavit to the forfeiture court consisted entirely of 7 pages of documents that were acquired by law enforcement after conducting a trash pull on Dr. Economan's residence on July 14, 2015. Little known fact, your trash, once it's outside the actual property on which you live, is considered public property. And so they went through the trash and they pulled out documents. And they're saying all she had was 7 pages from that. She didn't have any more than that. And I'll skip that next paragraph. And they say no further information regarding the plaintiff's seized accounts or their contents was ever requested by Cockrell or Wizenen. Moreover, Cockrell confirmed that even as of the date of her deposition, October 2nd, 2018, so 3 years later, she still has no information that would support the sworn statement she made on July 29, 2015. Moreover, and despite admitting that she had in fact signed the false affidavit under the penalties of perjury, Cockrell testified at deposition that her affidavit was actually created by Garrison and or Taylor of the Garrison law firm. So she's saying she didn't even write this herself, that it was written for her by the Garrison law firm, which was then going to receive a percentage of the funds that it collected. That's what the allegations here are. Specifically, Cockrell testified that the Cockrell affidavit was prepared by Mr. Garrison, prepared by Mr. Garrison's office, and that I added the and, that there was a gentleman from Mr. Garrison's office that prepared the Cockrell affidavit, and that someone in Greg Garrison's office prepared the Cockrell affidavit. Cockrell testified, I did not write those words. And then there are very similar allegations made about the Wizenen affidavit. The probable cause affidavit submitted by Wizenen alleged incorrectly that Dr. Economan issued more controlled substances than any hospital group in Indiana, to include Eskenazi Hospital, IU Health Hospital, and IU Methodist Hospital, all of which are major hospitals located in downtown Indianapolis, by a margin of at least 8,000 prescriptions. And he's going to say that's simply false. Wizenen alleged that supporting information from Inspect, Indiana's prescription drug monitoring program, was obtained pursuant to a DEA administrative subpoena in June 2014. This was not a true statement. So they're saying there was this claim that we had a basis for what we were telling the court, and they didn't. They didn't have a basis for that. That's what the allegations here are. In other words, the Inspect data actually revealed that Dr. Economan was issuing prescriptions for controlled substances at a similar rate as physicians still in residency who had yet to apply and receive their own DEA number. His assets were unlawfully seized for nearly 4 years, 1,283 days, and only then was the forfeiture claim dismissed with prejudice, voluntarily dismissed with prejudice. As a result, Dr. Economan lost his home of over 30 years through foreclosure and sheriff's sale, and his company was no longer able to operate, immediately ceased operations. He was forced to sell the majority of his unseized personal property to pay for his defense against demonstrably false allegations. In short, he lost his home, profession, business, life savings, and reputation in the community due to the above-named party's misconduct. So these are just, I'm pretty sure, there was a little bit more I wanted to read to you. Plaintiffs allege that the Grant County prosecutor, that's Luttrell, the Garrison Law Firm, and the Medicaid Fraud and Control Unit of the Office of the Indiana Attorney General, acting under the color of Indiana law, conspired to manufacture and or fabricate evidence against the plaintiffs and their property prior to having probable cause, and by so doing violated their rights to due process, et cetera, et cetera. Additionally, they allege that defendants, including the Grant County prosecutor and all the others they just mentioned, engaged in a conspiracy to unlawfully seize the plaintiff's property for the purpose of earning a percentage of the illegally seized property. And finally, they allege that they, acting under color of law, jointly and individually failed to intervene in a knowing violation of the plaintiff's constitutional rights. So let's talk for just a minute about what we just read. Okay, and thank you, Taylor, for the super sticker. I appreciate that very much. So what this is about, the doctor is saying you literally made up stuff and put it in affidavits in order to get permission to seize all of my assets, which you kept them for 4 years, and then said, oh yeah, sorry, we had no basis for this. That's what he's saying here in this complaint. We're going to see which of these claims actually held up, because just 2 weeks ago, there was an order from the court in a summary judgment motion. Now, what that means is there are allegations that are made by the court, allegations that are made at the beginning, but they aren't tested yet. Nobody's ruled on them. Nobody said these are true. These are just things the plaintiff, in this case, it's a civil case, the plaintiff comes in and says, these are what I think is true. And then there's a process. Everybody goes through some discovery. There are some documents produced back and forth. Depositions are taken. And then there is often in these cases, there's a motion for summary judgment. That's where each side, one side, whoever filed the motion for summary judgment, says, look, we can take a look at all of the evidence here that everybody agrees on, and we can look at the law and we can see that there's just not a case here. That's what the defendant would say. Or the plaintiff would say, we can see that I've proven my case and there's nothing, absolutely nothing they could say that would cause this to go away. Usually summary judgments are filed by the defendant, and the defendant says there's just nothing here, Judge. they've done their best. They just can't meet the elements of this claim. There's no way they can do it. There aren't enough facts out there. Even if you believe every single thing they say, there just aren't enough. And so that's what a summary judgment is. Everybody puts the evidence before the court, hasn't gone to a jury yet. A summary judgment will be ruled on by the court, and the court will either say, yeah, this needs to go to a jury, and I think there's enough dispute between the parties, a jury ought to make a decision. Or we'll say, you're right. This is all over. This is some summary judgment, and I'm going to go ahead and make a decision here. And in this case, the judge made what is kind of an unusual decision in favor of the plaintiff for summary judgment. That is not normal. Almost all summary judgment motions come from the defendant saying, get rid of this case. There's nothing here, judge. There are a few cases where the plaintiff will file a motion for summary judgment, and it happened here, and the court ruled with them. So let's back up a little bit and talk about, remember, our focus is on the Richard Allen case. What you have just seen is allegations that a prosecutor in the case created affidavits and made up facts. He was involved in a group that did this in order to steal somebody's money. They weren't real. They weren't accurate. This person was being prosecuted for no real reason. There was no factual basis for it. How you can see immediately where that could go. That sort of reminds me of what happened in Karen Reed's case, what her allegations were, and you can see where it might make a difference in Richard Allen's case. But I'm going to talk to you about why I don't think it will at the end of this. First, though, let's look at what the judge ruled. This is a very unusual order, and I tell you that because of the fact that this is actually granting the summary judgment of the plaintiff in large part. So I just have a few sections in here I wanted to read to you so you can understand. I will read the paragraph to you because there was a little more to it than it sounded like when you just read the complaint. And they talked about around the time the Medicaid Fraud Control Unit received that complaint, Defendant Cockrell received reports from a printing company that plaintiff Economan was ordering large numbers of prescription pads for controlled substances. We'll skip that next. After learning her colleagues made undercover buys of controlled substances from plaintiff Economan's patients, she and Defendant Wisenan, a longtime DEA officer, interviewed the printing company who reported the large orders of prescription pads for controlled substances. They also interviewed pharmacies who reported concerns about plaintiff's prescribing habits. So those were the facts they had and the things they were looking at. Then let's hear what the court said after looking at the facts as they were submitted by both sides for this. All right, beginning with Defendant Wisenan's affidavit. His was written with Defendant Krug's assistance and reviewed by Defendant Luttrell. That's the prosecutor. In his deposition, Defendant Wisenan admitted, this is the court writing. This is no longer the plaintiff writing. This is a federal district judge writing this. Defendant Wisenan admitted he had no evidence, let alone probable cause, that plaintiffs committed the criminal offense of corrupt business influence, despite the allegations and conclusory statements in his affidavit. Defendant Wisenan also admitted he had absolutely no evidence that plaintiff committed Medicaid fraud when he swore and affirmed to the same. That's shocking to me. I'm just going to say that is absolutely shocking that the federal judge is actually is finding that there was an admission by Defendant Wisenan that he had nothing. He did not have the evidence. He did not have the probable cause, and he filed it anyway. Finally, Defendant Wisenan admitted he had no evidence that plaintiff Economan was involved in money laundering. Defendant Wisenan also included inspect data in his affidavit, despite his and Defendant Cockrell's joint knowledge that inspect data was not permissibly used as evidence. Defendant Cockrell's affidavit fares no better. Although her affidavit was prepared by Defendant Garrison Law Firm, Defendant Cockrell still signed it, affirming the truthfulness of its contents. Her affidavit is focused entirely on the bank accounts that allegedly contained proceeds from plaintiff's criminal enterprise. However, defendant Cockrell has too since admitted her affidavit was inaccurate in stating she had good cause to believe that the account seized from plaintiff contained significant funds from a criminal enterprise. I mean, absolutely shocking. Of the 8 accounts seized from plaintiff, defendant Cockrell admittedly had good cause to believe that at most 2 of the accounts contained significant proceeds of a criminal enterprise. This is truly amazing. She's saying that she admits that she took 8 accounts and at most 2 of them could have contained significant proceeds of a criminal enterprise. She's saying she was inaccurate in saying that she had good cause to believe the accounts contained significant funds from a criminal enterprise. And the court is saying that. The court is saying, I find this. This is what the evidence shows. And keep going. The evidence demonstrates the defendants, remember Luttrell is one, did not have probable cause, let alone a preponderance of evidence that plaintiffs committed the offense of corrupt business influence or any other crime, which would make a civil forfeiture proceeding appropriate. These are really strong findings. These are very strong findings by a federal judge, and that is very, very serious. But I'll talk for just a minute about what I think related to, and there's not much left to read on this. The court begins its analysis with defendant Wissenden's affidavit used for the civil forfeiture order and search warrant. It was written with the assistance of defendant Krug and was reviewed by defendant Luttrell. Inspect data.
Found something else to watch because I wanted to see this.
For joining us. Matt Murphy is with us, our ABC legal analyst, former prosecutor, and homicide prosecutor. So this is an important topic for so many in our area here in the Inland Northwest. We're talking about the changes that we're seeing with the Kohberger trial, how it's moved from Latah County to Ada County, and all of the changes that we expect to see in the coming weeks and months ahead. So thank you, Matt, for being with us today. We appreciate it.
Happy to be here.
So first off, we just found out in the last week that this trial is going to be moved now to August of 2025, which is 3 years, almost nearly 3 years since the murders of the 4 University of Idaho students. So talk to me about, in your experience, how unusual, or is that even unusual, to have a trial moved back that long?
Well, when you're talking about capital case litigation, he's looking at the death penalty. So the name of the game, especially in the Ninth Circuit Court of Appeal, which is what oversees this case, which is the same as California, the name of the game is avoiding appellate issues. So for anybody that's actually done enough of these, essentially that is more than half the battle in any case like this, because the worst thing that can happen from the prosecution standpoint and also the court standpoint is to have a jury go through this, have all these families go through this, only to have the case reversed because of some sort of error. So what that means in reality is it means that the defense essentially gets all the continuances they want in a case like this, because you never want to set a case up for what's known as IAC, or ineffective assistance of counsel, which is one of the most commonly alleged reasons to reverse a capital case. So if it actually goes in August of 2025, believe it or not, in the death penalty world, that is pretty much light speed. I had cases that took a decade to come to trial in the capital case realm. So if they can get it that fast, that's, believe it or not, that's actually very fast for capital case litigation. As far as the transfer to Ada County, again, this is one of those things that the defense brought the motion, and it's an abundance of caution move by the court. By allowing them to do that, they're essentially eliminating issues. I think it was the right call just to ensure the integrity of this conviction. And look, the evidence in this case, in my opinion, is overwhelming against Mr. Kohberger. It is incredibly persuasive. I've presented cell phone evidence like this before, and the DNA evidence that's on that knife sheath is also very compelling. The phone tower pings is very, very persuasive in front of a jury. And I think that the judge sees that, the prosecution sees that. That's why the prosecution didn't really put up too much of a fight when it came to changing the venue, because I think you're going to get a jury very similar to what you would have had in the original venue. And I don't think it doesn't hurt the prosecution case a bit. And I think it's actually smart by the court to do it that way, because it ensures the fewest issues on appeal possible.
Wonderful. Okay, that actually answers a bunch of the questions that I have for you. So it may get a little repetitive here, but I do want to ask and kind of go back to what you just said about having cases that lasted a decade. Would you say then we should expect more delays in this trial?
I wouldn't be at all surprised to see more delays in this trial. It's for your typical just run-of-the-mill murder case in California, not even a death penalty case. And every county is a little bit different, but in Orange County, I mean, our average, maybe for generic run-of-the-mill, nothing to it, like 7-Eleven robbery or domestic violence homicide, it's 3 to 5 years to get those to trial. It's very important that the defense receive all the discovery, that they've had an opportunity to properly investigate. And, in a way, you want to do that. You want to ensure that the rights of the defendant are scrupulously honored so that there's no appellate issues, and just to be fair, and you want to extend the professional courtesy to professional defense lawyers. And that's the way it should work. But when you get into capital case litigation, they receive the highest level of appellate scrutiny. That means they're going to get the longest, hardest, closest look by the courts of appeal. And we want it to be that way, right? And in the state of Idaho, this very well might be an actual death penalty case. In California, there's a moratorium that's been declared by the governor. So nobody's getting executed in California probably ever again. But in Idaho, it might actually happen. So you want to be careful. You want to make sure that it's right, because when you're talking about the ultimate penalty, the integrity of the system kind of demands the most careful step-by-step process that they can provide. And so it makes sense. It takes a while. And it's also very important to remember, look, as a prosecutor, I never really cared if the guy was in custody sitting in jail versus in prison. Never really mattered to me. They're not going to hurt anybody else. Jails are usually maximum security. So although escapes happen, it's very rare. And if the guy is sitting in a cell in a quote unquote jail, or sitting in a cell in a prison, it doesn't really make that much difference. He's off the street, in my view. And I know the families really want this to go, and they live with the apprehension. And that is a very critical part of any case like this. For me, it was always really, once you get past protecting the constitutional rights of the criminal defendant in a homicide case, the next step for me is always the families of the victims. You want to make it as easy on them as you possibly can. And I know that one of the families didn't want the venue to be moved, but which I understand. We have to be sensitive to that. And really the prosecution should be spending a lot of time talking to them, making sure they understand the process. But the only thing worse, and they haven't been through it before. So they've been thrust into this situation. It's overwhelming. It's complicated. But the only thing worse than, the inconvenience of maybe having to drive to another county and get a hotel is a case that gets reversed because the court, denies a motion like that. So it's careful steps, methodical steps to ensure the rights of the defendant, but also in the long run, as long as it's upheld on appeal, the family should be, for the temporary inconvenience, they'll benefit in the long run.
I'm glad you brought up the families, because in our area, Moscow, Spokane, Coeur d'Alene, the entire inland Northwest, when this happened, really found connections to these 4 families, whether it be the same summer camp that their kids went to, or the University of Idaho, of course. So many alumni are here in this area. So there are just a lot of personal connections from our viewers who watch and are following this case. What do you make of you said you believe that the state has this case, figured out. What do you make of the gag order in this case? Because from our side, we found very little information from the very beginning. I mean, there's no murder weapon. We have the knife sheath that you talked about, and there's the DNA, but we just don't know a lot of the details that we assume will be coming out in the trial.
That's right. And I think that, I'm guessing here, and I haven't read the file, of course, but I think that where this went wrong at the very beginning is there are a bunch of online sleuths who pegged one of the professors at this university as being the killer, right? And I think that the interest in true crime personally is a good thing, at large. Like,
Are you ready?
Taken as a whole, the public educating themselves about things like DNA evidence or cell phone pings, I think we benefit as a society from greater education, which the interest in cases like this really is. It's this is a very topical thing. I think generally we win, and social media generally is a good thing on this. But every once in a while, it goes off the rails, and it did in this case. So you've got some poor professor that had nothing to do with this at all, and you got some sleuths who decided that was him. And now that guy's name, anybody who Googles it, for years and years, I mean, we're presumed innocent in the courtroom, but we are not presumed innocent in the court of social media. So I think that weighed in personally in the judge's decision on that somebody had already been hurt by sort of the rampant speculation. And again, the court's job here is to ensure the integrity of the case. They want to make sure that the rights of Mr. Kohberger are adhered to very carefully, because the court is looking at the big picture. The court doesn't want this getting reversed because of any mistake. Okay, so that's I think that these judges have been doing a pretty good job of that. My only concern, I wouldn't even call it a criticism, is for the prosecution on this, they've got to, the way the family keeps making statements publicly, or at least one of the families, maybe multiple families of these poor victims, it seems to me like nobody has sat down with them and explained the benefits of, why the change of venue actually doesn't hurt them and why it's actually a good thing. And, I don't know that, but, if I had a family, I did a lot of high profile cases. I worked homicides exclusively for 17 years. None of my families are giving press conferences, when, a hearing didn't go our way or there was continuance granted by the defense, because my bereaved family members all understood the process. And, that's my only question here is, has somebody actually sat down with them and walked them through the complex, ins and outs of the criminal justice system, especially in capital case litigation, because you're guaranteed to get a change of venue motion in a case like this. I mean, I was kind of surprised it granted it, honestly, but I understand exactly what it did. I think it would have withstood appeal had it been denied, but these judges are doing everything they can to ensure the integrity of this case, especially if he's convicted, and I think he's going to be convicted. I mean, this evidence is really powerful stuff. And of course, you're right. There's also a bunch of stuff we don't know. They got into his computer. I guarantee there is evidence that we do not know about that was recovered from Mr. Kohberger's computer or cell phones. Guaranteed, because there always is. And we haven't heard about that yet. So this isn't just about the phone pings, the video of the car, and the DNA on the knife sheath. There's going to be more to it than that. And you're right, we don't know what it is yet, but that's the court and the prosecution trying to be very careful to ensure the integrity of the conviction.
And our next hearing is in November, and that's going to be motions that are or from the state arguments about the death penalty because the defense is trying to remove the death penalty. What do you expect us to hear in that hearing?
Yeah, look, the defense, one of the biggest challenges on appeal, again, is that IAC thing. And what happens is the appellate lawyers who get involved in a case like this have no allegiance to the trial lawyers. So they will immediately begin throwing them under the bus. They will accuse the court of judicial error. They'll accuse the prosecution of misconduct, and they'll accuse the defense of whatever they think the defense didn't do. And so it's kind of it's a pretty ruthless and mercenary period of armchair quarterbacking every decision they made. Okay, so on one hand, the defense has to bring every motion imaginable in order to, again, to cover themselves, essentially. And what that means is we're going to see a bunch of motions that essentially are nonsense. And, you know, we've seen some of those in this case already. We saw this, hey, Judge, you have to interpret the Idaho statute concerning capital case litigation as, you know, non-existent because of the original charter for the state of Idaho. And that was interesting. It was novel. The problem is that if you research that, which I did, that issue has been raised over and over again, and it's consistently been shot down by the courts and by the courts of appeal in the state of Idaho. So that sounded very dramatic when we read about it, but you know, that was going nowhere from the word go. And I think that what we can expect to see in November is exactly the same thing.
And I think it's important for people in our community also to understand, you have prosecuted many homicide cases, high profile. This is what was at one time an internationally known case. So this is kind of the largest stage that you get to. We are going to start to see, it looks like in the next year, the questionnaires for the jury go out, and we don't ever get to see those. But you have a better idea of what are some of the questions that are asked of these potential jurors to ensure that this is a fair trial. Yeah, just to kind of flow with what you just said, I was the Orange County prosecutor on the Golden State Killer. I did Rodney Alcala, the dating game killer. I had, you know, Skylar De Leon, who murdered Tom and Jackie Hawks on their yacht. I have been in and around capital case litigation for my entire career in one form or another, and I've been doing this for 32 years at this point. So what we're going to see in those questionnaires is the prosecution, and this is another thing that nobody seems to know, they're entitled to what is known as a death qualified jury. Okay, so what that means is this isn't just, you know, we're going to get random people from the community and hope for the best. They have to weed out people that are either religiously or politically or ideologically opposed to being able to follow the law. And the law of the state of Idaho says that the jury has the option of imposing the death penalty. So it's a gigantic waste of time if you put people on there that can't vote for death. And essentially what the jury will be tasked with doing is in California, they're called A through K factors, but it's essentially their job will be to weigh and consider the aggravating versus mitigating circumstances. So first, it's a bifurcated process. Okay, so what that means is first the question is, did he do it? Is Mr. Kohberger the actual killer? Okay, and the jury is going to convict him of that, is my prediction. Then the next part, perhaps arguably the most important part, is now that we know that he's the person who did it, the jury has to consider what are the aggravating factors, including victim impact, which means the family members of these poor kids that were slaughtered in that house will get to take the stand and talk about the impact they had on their lives. And then in California, it's called B factor, other crimes of violence, which Kohberger doesn't have. But then they'll consider all, like, any points of mitigation. Was he abused as a kid, which he wasn't? Well, you know, was he under the influence of drugs at the time, which it doesn't appear that he was. So they'll weigh all of these different things under the law. They'll weigh and consider, and if the aggravating factors substantially outweigh the mitigating factors, you need a jury that is capable of imposing the death sentence. If based on balance, they have to be able to vote for it, just like they have to be able to vote for life without possibility of parole, which is option 2. Okay, so it's like one option is death, one option is life without possibility of parole.
They have to be equally open to both. And so what the jury questionnaires are designed to do is vet out people that either couldn't vote for life without possibility of parole. In other words, they're too emotionally
Being able to have something to always protect myself with this Byrna allows me to have that peace of mind no matter.
Caught up in the idea of somebody that would slaughter these 4 innocent kids, that they could never open their mind to the idea that there might be mitigating evidence that may in balance speak to something less than the death penalty. And likewise, the people are entitled to, or the prosecution is entitled to, a group of people who objectively, in a sober way, going through that law and going through the aggravating factors, if they decide that it substantially outweighs any factors of mitigation, they have to be able to have a group of people that could impose the death penalty. Okay, so that's the way it works. So the questionnaires, and I've read more of these in some parallel universe, I'm still reading them from my last capital case that I did. It'll be about a 20-page questionnaire on, can you impose the death penalty? Do you have any religious beliefs, ideological beliefs, political beliefs that would prevent you from being fair? What sort of news stations do you watch? Where do you get your information from? Do you belong to any organizations that advocate for or against the death penalty? And each side is entitled to that. Kohberger himself is entitled to people that have to be open-minded to life without possibility of parole. The people and those victims' families are entitled to a group of people who can impose the death penalty. And that's the way it's supposed to work. And that's why, I'm pretty nonplussed about Ada County. I would love to have, Idaho juries. You're not going to get anybody. Yeah, I mean, you're entitled to people who can impose the death penalty. Whatever county you wind up in the state of Idaho, you're going to be able to find 12 people who are going to be fair. And that's what Kohberger is entitled to. That's also what the victims are entitled to. And they're going to find that. And whether that's in, the upcoming August, and hopefully it will go that soon, or whether that's the following year, or whenever that's going to be, they're going to find that fair jury. The judge, hopefully, so far they've done a good job of this, in my view, of ensuring that, the defense is given what they need to properly prepare, and then they will fairly preside. The jury will assess this evidence. They will convict him of this, I believe, and then they'll decide whether or not it's worthy of capital punishment. For what it's worth, I sat on our capital case committee for 15 years. I reviewed a lot of cases. We only sought death in less than 4% of the cases that qualified for death. Most murders aren't even special circumstance murders. So the vast majority of murders don't qualify in the first place. Of those that do, we would seek it only in the rarest case. And this case would have, I think, satisfied everybody on our committee that this merited pursuing the death penalty. I mean, it's that vicious, it's that gratuitous, it's that unnecessary. These kids with that innocence is that horrific, and the evidence, in my view, is that overwhelming.
And I have about 7 or 8 more questions that I'd love to ask you, but we don't have enough time. I do want to ask you about, no, I could just talk to you all day, but I do want to ask you about your book, because you have written a book, and I think, like we mentioned at the beginning, there's a lot of true crime enthusiasts that are following this case. Yeah, and they may be interested to hear, just your perspective.
Yeah, you mean about the book?
Well, why did you write the book, and what can they find in the book?
So it might be a little twisted, but I wrote the book because after 17 years in that unit, 26 as a prosecutor, I missed it so much that I missed my team, I missed my crime scenes. The way it works in Orange County is we would actually go to our own crime scenes. So most places don't do it that way. Most of the time the police investigate. One DA reviews it for filing, another does the pretrial, another does the prelim, and somebody else tries it. In Orange County, you show up yourself. So you're assigned patches of the county. I had Newport Beach, Costa Mesa, Laguna, and Irvine. So any murder that happened in one of those cities for 17 years was automatically mine. I'd roll out my investigator in the middle of the night and start before the body was moved of the poor homicide victim, and with detectives, figure it out every step of the way. And I learned so much in that unit, and there's so many fascinating stories to tell. And I decided that it was worth sharing. I pitched it to Disney. They liked it. I wrote this thing. So it came out a couple weeks ago. It's called The Book of Murder. And essentially, I walked the reader through my career in homicide, my first homicide, my very last trial. And I go through the legal concepts. What is a death penalty? How does DNA really work? And I also go through about a dozen of my more high profile and interesting cases, in chronological order, kind of a taxonomy. I do a gang murder. I talk about that. And I get into, the abuse of a child, the kidnapping, and Samantha Runyon, and all the way up through Tom and Jackie Hawks, and then finishing with my Hussein Nairi case, which is about to be a 3-part series on Hulu. And that's a fascinating case too. So it's doing pretty well. I think people are liking it, which the Audible is doing particularly well, which is a mystery to me because I cannot stand the sound of my own voice. But people seem to really be embracing the book, which is humbling and gratifying all at the same time.
Okay.
Okay, y'all, I have no idea where the hell Kane is. I don't even know who's in here. Or what the freak to talk about, because there's nothing else going on in these cases. Delphi doesn't start till I think tomorrow. And we just have to wait on Andrea, Lana, whoever to tell us, because they're not even letting audio go on with that. They've got to mess with that case, it seems, too. So I don't know where this man got his information from. As he said, he ain't read nothing. I wish they would quit getting up here speaking without reading stuff or knowing what the hell's going on, which I guess they could have. I don't know what they've got. I haven't figured out why this case is going to go on for 3 months or however long this trial is going to be. So whether the information they have is relevant or not, they've got information, something. I don't know whether it's going to be against Kohberger, but they've got some kind of something for a trial to go on that long. For a trial to go on that long. And I don't know where Kane is. But I really don't have anything else right now. If they put out documents or whatever, I'll do another live. There's a couple of readings I have coming out tomorrow. One's on the Menendez brothers, a Delphi reading, and Clive Davis. Yeah. P. Diddy's his manager or whatever, that stupid man. This oldest ancient, I don't know what. But anyways, he's disgusting. But I have those coming out, and I think that's it right now, y'all. And I'm gonna beat Kane up because I don't even know why he wanted me to go live, because he didn't even come over here. But anyways, y'all have a good evening, and I will see y'all whenever there's something to talk about.